welcome to this special invitation-only production of Conservative Conversations with ISI on the topic of the battle for the Supreme Court. My name is Johnny Burtka, and I'm the president of the Intercollegiate Studies Institute. And it's a privilege to welcome you to this special conversation where we will discuss the Senate confirmation hearings of Amy Coney Barrett and its implications for the future of the court, conservatism, and the country. If you're joining us tonight, it's because you've been a loyal supporter of ISI, specifically of our mission to educate the best and brightest college students in the principles of liberty, the American founding, and our Western heritage. On account of your generosity, we've been able, throughout the past 67 years, to produce the educational programs and network needed to educate America's best leaders, including two Supreme Court justices, Justice Neil Gorsuch and Justice Sam Alito, the president of Hillsdale College, Larry Arnn, the co-founder of PayPal, investor and entrepreneur Peter Thiel, and many more. And on account of your continued generosity, we are able to host over 140 campus events, conferences, and debates this academic year alone. So thank you for all that you do for ISI, and we're excited to welcome you to our conversation this evening. Couple housekeeping notes. We would encourage you all to ask questions. And on the right side of your screen, there's a comment box where you can type your question. Your question won't be public, but they'll come directly to me, and then I can curate and select the best questions for our panelists. So without further ado, I'd like to introduce our esteemed group of panelists. First, we have Ambassador C. Boyden Gray, who served as White House counsel to President H.W. Bush and was in charge of judicial selection. He also served as ambassador to the European Union under George W. Bush and is the founding partner of Boyden Gray and Associates, a law and strategy firm in Washington focused on constitutional and regulatory issues. Next, we have Josh Hammer. He is the opinion editor of Newsweek, a research fellow at the Edmund Burke Foundation, of counsel at First Liberty Institute, and a syndicated columnist through Creators. A frequent pundit and essayist on political, legal, and cultural issues, Josh is a constitutional attorney by training. And last but not least, we have Rachel Bovard, an ISI alumnus from Grove City College. She is the Senior Director of Policy at the Conservative Partnership Institute. Rachel has over a decade of experience fighting for conservative values in Washington. Beginning in 2006, she served in the House and Senate in various roles, including as legislative director for Senator Rand Paul. He is the co-author of a recent book, Conservative: Knowing What to Keep, with Senator Jim DeMint. Please join me in welcoming our panelists. Well, thanks so much for joining us. To kick things off, I know that you've been writing, thinking, and tweeting a lot lately about the current situation on the Supreme Court. And I'd just like to get things started by asking each of you to lead off with your opening thoughts about what you witnessed today in the confirmation hearings for Amy Coney Barrett. So why don't we get started? Ambassador Gray, I'll turn to you first.
Well, my take from it, and I didn't watch all of it from beginning to end, of course, but my take from it was they know they don't have the votes. Who knows what games they may play procedurally later on, but they're turning this into a healthcare issue. And it's a campaign, game for them to insist that she's going to repeal or wipe out the Affordable Care Act in the middle of this pandemic. And I think that's very speculative at best. And I don't think that that's going to happen. It's a technical severability issue. The tax issue was taken off the table by the tax bill. And the question is, does that kill the rest of it? Well, under most case law, no. The rest of the Affordable Care Act that isn't affected, and it continues forward. That's my guess as to how it'll come out, but no one knows how she will vote. And she's not put there to do that. And the Republicans would seek to get her confirmed before before the election, even if the case weren't scheduled for a week later.
Thanks, Boyden. Josh, what are your thoughts?
So first of all, Johnny, thanks so much for having me, obviously. This is a great panel. Your Hillsdale College classmate and one of my best friends in the world, Elliot Geiser, is actually also an attorney for Boyden. So that's kind of a fun connection on this panel. And obviously Rachel Bovard, one of the greatest conservatives in the 21st century conservative movement. I feel confident in saying that. So really delighted to be here, and let's have a good conversation. I mean, I watched pretty much all of what happened today, and nothing particularly caught me off guard. I mean, what Boyden said is accurate. The Democrats don't have the votes, period. They don't have the votes. They perhaps will force Lindsey Graham, Mitch McConnell to get procedurally creative as far as quorum requirements. That's kind of more Rachel's wheelhouse. She can probably talk more eloquently about that than I can, frankly. But Amy Coney Barrett is getting confirmed, and she is getting confirmed before November 3rd. And I think that she will be an excellent justice. She was probably not my true first choice. That honor would probably go to my former boss, Judge Jim Ho of the Fifth Circuit. But she's an outstanding choice. She's hired a lot of my close friends from the University of Chicago Law School. In fact, my former roommate actually was on Fox and Friends this morning as a former Barrett clerk. So she hires good people. She's written many high quality opinions. And they really have nothing. I mean, for a while there when Justice Ginsburg passed away, my initial instincts were, oh my gosh, of course, this is Justice Ginsburg. She's the lion of the left. This is going to be even worse than Kavanaugh. This is going to be Armageddon, like hell on earth. But the reality is they have nothing. What can they possibly say against a 40, I can't remember her exact age, 47, 48-year-old mother of seven, we all know the story, 2 Haitian adoptees, the Down syndrome child, beautiful family, very poised, elegant, comes from Louisiana, went to law school in Indiana, such a welcome, fresh breath of air, away from the Harvard, Yale law school mafia. So they really have nothing. I expect the anti-Catholic bigotry to ramp up, despite some of their protestations to the contrary. I expect that to continue. I was very happy to see people like Senator Sass and Senator Hawley this morning come out swinging against that, as they of course should. But Amy Coney Barrett is getting confirmed, and my best guess is the kind of justice that she will be. I don't think that she'll be quite Clarence Thomas. Query whether anyone can be quite Clarence Thomas. My best guess is that she will be somewhere between Alito and the kind of the Gorsuch-Kavanaugh position. On the median vote, obviously, is going to be issue specific, but I would predict probably closer to Alito. But nothing today gave me any pause for concern. I'm very excited for her successful confirmation.
Great, thanks, Josh. Rachel, your thoughts?
Well, thanks, Johnny, and to Josh as well for your hyperbolic comments, but I'll accept them. I think Josh is right in the sense that, and, Ambassador Gray made this point as well, she's going to get confirmed. This is not an open question. It's just a matter of what the focus is going to be. And it was kind of shocking today, I think, a little bit in the sense that, Judge Barrett, as part of the Seventh Circuit, has written participated in close to 700 opinions on the Seventh Circuit. She's written close to 100 of them. And not once did we hear a question about her jurisprudence. All we heard were rants about healthcare. We heard about COVID-19. We heard about COVID-19 relief, all policy battles that have absolutely nothing to do with her job and her role in the Supreme Court. And you heard several senators make mention of this. Senator Lee in particular doubled down on this, saying, look, judges aren't policymakers. That's not their job. And Senator Sass followed up on that as well. They don't have anything, I think, grotesque, or any rage charges to push against her like they did with Justice Kavanaugh. You are seeing a little bit of that, fringe left, I think, mount these really disgusting attacks on her children. You saw Ellie Mistal tweet about how she was, somehow implicitly making racist comments about her own children. You saw Slate magazine put out a tweet calling her a shameful careerist or something, overtly sexist towards a female nominee who's also an outstanding mother. So I think in that sense, it's unmasking the left, I think, for their hypocrisy toward their treatment of women. But I think other than that, on the issue itself, they have very little. But I do not think this is going to be. I don't think the left is going to mount a robust analysis of her jurisprudence because they simply don't have it. They'd rather sort of smear her, and I think that's sort of what we're going to see in the questioning going forward.
Great. And as a follow-up to that, I got a question from one of our listeners. They said, we heard today the Democrats plan to boycott the Senate meeting at which the Senate Judiciary Committee will make a motion to approve Judge Barrett, which will prevent the nomination due to lack of a quorum. Can that work?
So the Judiciary Committee's rules requires two Democrats to be present to move forward with business. However, that is a rule that can be changed and I expect will be. I don't think, just based on the comments from Senate Republicans, that they're going to tolerate any of these shenanigans. They have the ability to move forward with this nominee, and they will. I just think, frankly, it's immature for Democrats to pull this, and I think it will backfire on them spectacularly should they do that.
So what timeline are we looking at? The week before the election, or do you think this could be sooner?
It looks like the week before is I think, best guess. I think Senator Graham said today he expects to start the markup on her nomination on Thursday. Democrats will move to hold that over, as is their right. So you're not looking at anything until probably October 22nd, I think is the closest to when we're going to see the nominee reported out and move to the floor. Now on the floor, Democrats, have opportunities to make dilatory motions, motions to adjourn, approval of the journal, trying to go back to legislative session. All those things require votes. But again, you're moving forward on this. You're on a train that's moving forward. Their votes are there. She just needs 51 votes to be confirmed and to invoke cloture. And I think that's what we're going to see.
I think we
Johnny.
lost Johnny.
Josh, do you have anything to add to what I said regarding?
Well, until Johnny comes back, Rachel, you're the procedural expert here, obviously. I guess my only question would be, and this seems to be a popular question given the positivity for Senators Tillis, Lee, Ron Johnson, et cetera. Can, if need be, senators vote from the gallery, from the nosebleed seats, so to speak, in the upper deck? I mean, could we get to that? Do we need to get to that? Is that possible?
Yeah, I think the left's going to make a big deal of this. You saw them make a big deal about the fact that Senator Lee was in attendance today after he tested positive for COVID-19, despite the fact that he was cleared, by the Senate's attending physician to be there. So I think you're going to see them make a big deal about it. They can vote from the cloakroom. They can raise their hand and do it from there. So I think they'll put procedures in place. Democrats are going to make a big deal about it anyway. But I do think that they're going to be able to overcome that.
All right. Another question for you. So Congress hasn't changed the court's size, 9 justices, since the mid-19th century. There's been considerable discussion as of late that if Joe Biden is elected president, that he might consider expanding the size of the Supreme Court. What does that mean for our constitutional understanding of the court, and do you think that that's likely?
Well, I'll speak maybe to that first. Wouldn't be unconstitutional technically, because the Constitution doesn't set the numbers, and nor does Congress really. Congress can change its mind about it, but it's not a constitutional number. But it has been a number that fits very well for the working of a collegial body. And I think if you went to 15, it would just so change the character of the gathering that it wouldn't be collegial. It wouldn't be in any way susceptible or welcoming to frank argument. And it would be like a minor legislature. I'm sort of reminded of what happened at my college alma mater, which I hate to sometimes admit was Harvard. They went from a 5-person corporation, which really ran the place, into term limits, terms for 15 members, expanded it enormously. And all of a sudden it dissolved as a director of what happens at Harvard, and the atmosphere has changed so that it's the president who really is calling the shots, not any oversight board at all, not the board of overseers, which is way too big to be a body to be collegial. So I think 9 is the optimum number. It's gone up and down, and this is where it's settled quite a long time ago, last century, 2 centuries ago. And I think it'll stay that way. And FDR, times are different now than they were then. But FDR had the votes to do it, and it backfired on him big time. So I just don't think they really ought to try to do it. One of the ironies of it is that the argument's not working for them, but they're saying that this is a court packing exercise, putting Judge Barrett on the court, but he won't reveal either, that is Biden, won't reveal either whether he will try to pack the court, assuming he gets control of the Senate. He won't reveal whether he'll do that, and he won't reveal who his potential nominees might be. So how can he possibly argue that somehow the president is, or the Republicans are playing games with this nomination? It's totally inscrutable. And so I don't think they'll try it. And I think if they do, it'll backfire.
Rachel and Josh, would you agree that it would be politically disadvantageous for Biden to attempt to pack the court?
I'm happy to hop in. So I think insane times, in times where civic efficacy in America is decent, and in times where more than 32% of America, or whatever the relevant polling tells us of Americans, can name but one, let alone all 3 branches of government. I hope I didn't misspeak there, but it's pretty astonishingly terrible. I think in saner times, this sort of total partisan politicized stunt would backfire. Obviously, in middle school and high school, in history class, American history, you learn about FDR and the switch in time that saved 9 in 1937 and all of that. I query whether we are in a post-caring era, in an era where the median American citizen has forgotten what something that I think literally only 25, 30 years ago, probably at the most, would have been a death knell. I really think that the Biden-Harris stance on refusing to tell the voters their own position on court packing, just the dripping disdain and arrogance of this viral Biden clip that we saw from over the weekend, how the voters don't deserve to know. In a just society, that is a singularly dispositive deal breaker that really ought to cost you the election. I'm just very cynical, as I think a lot of us on the right are, looking at present opinion polling on so many issues, and looking at the anarchy and the mayhem and the arson and the riots in the streets. I hope that this sort of stunt would backfire. But I'm cynical and pessimistic enough where I'm not sure that it would. But we are talking, as Boyden said, 1869, it was the year that the number of justices became fixed at 9. And it's true, there's nothing in the Constitution that requires that. Query whether that's a good thing or whether it should be a constitutional amendment. I think reasonable people can disagree on that. But the substantive risk, of course, of packing the court and both sides kind of going back and forth and only stacking justices when they control the White House and the Senate, is you end up then realizing into very concrete terms the worst fear of the court, especially in the post-Warren Court era, which is that the court ceases to be a court in any meaningful dictionary definition of the term and just becomes the super legislature that the, again, post-Warren Court left has treated it as anyway. And, historically, conservatives, I think, rightly have pushed back on that. We've pushed back on judicial supremacy and false legal doctrines like that would elevate the court to a super legislative status. But by packing it and engaging in this kind of, or commencing this back and forth mudslinging, I mean, who knows where the merry-go-round ends? 25, 30 justices? I mean, who knows? It would be tremendously destructive. The court would stop being a court in any meaningful sense of the term. And the results for a self-governing people where, there's something to be said for achieving the common good within the lowercase r Republican construct of the legislative process, would take a serious, perhaps grievous blow, I think.
Yeah, I think, to that point that Josh made, it's a smart one, which is that, the left already views the Supreme Court as its, legislative body for the country. And that is why I think there's so much focus and intensity around it. And this was on display a little bit today at the a lot today at the hearing, with every appeal on every major policy question, as if the court is sort of the, arbiter and sanctor of all of these policy questions, when in fact, the great irony of that discussion is that these are senators. These are senators with the constitutional mandate and legislative authority to affect all of the policy questions they are throwing up their hands about that might be decided by the Supreme Court. The answer to a tyrannical judiciary in any sense of the word is for the other branches to press back against it, right? And the legislature to assert itself against whatever the judiciary has done that they do not favor. But we're not seeing that, right? We're seeing the sort of supine legislature, a deference to the courts in a way that makes them reflect the policy preferences of America. We have outsourced the legislative role to the courts. And so do I think that Joe Biden will go down this court packing road? I think the pressure on him will be immense to do that, because that is how the left views this court, not as sort of, its proper role as sort of an arbiter of constitutional questions, but as the supra legislature to dean down on the populace what should or should not be done. So I do think it's a real threat. And the fact that he won't answer the question sort of even makes it more so to me.
Thanks, Rachel. Boyden, maybe you could answer, at what point in history did the Senate, the legislative branch, stop sort of exercising their policymaking authority, and when did things really transfer to the court?
Well, that's a very interesting question, which I've tried to delve into. It hasn't been much discussed in the law review articles or other magazines or other journals or on television. When I first came to Washington, which is before our two other panelists were probably born, the Congress did discharge its obligations. And I tell the story about how now today I will ask a big audience, sometimes as big as 1,000, how many in the room have ever heard of an amendment to the third degree? And not a single hand will go up. And then I will ask the question, has anyone here ever been to a markup session? That being a session where the subcommittee or a committee of House or Senate debates the bill, takes amendments, accepts them, rejects them. Amendment to the third degree is you can't amend an amendment to an amendment. And so that becomes a big sticking point if the bill you're using is itself an amendment to the original legislation that was introduced. All of that was common knowledge, and markup sessions and conferences between the House and Senate after they reached a bill in different form in each house. Those were great spectacles. I'm not sure they were as good as a really good Supreme Court argument, but they were a good rival. I used to do a lot of legislative work and during the days when it really mattered. And it was very serious stuff. And they took their jobs very seriously. This is in the 70s and 80s. When did it all change? Well, I would actually pin the blame on a Republican, which I hate to sort of do. But I think if you had to pick one single event, it was Gingrich's election or selection as Speaker of the House, and his drawing all of the power into the Speaker's office, denuding, emasculating the committees and the committee structure. Pelosi has carried this on to the point where she gets up and says, we got to introduce this bill, the ACA, the Affordable Care Act, in order to find out what's in it. Back when I first came to Washington, you couldn't come out of a markup session or a conference session with any doubt about what any word meant. And that's all changed with the aggregation of power in the Speaker's office and in the Majority Leader's office. And I don't mean that critically of McConnell. That's just the way life now is. Regular order is gone. And so if you add that to the, I know this is going to sound strange, but you add that to airline deregulation, which cut the cost of travel by 2/3 or 3/4, allowing members of Congress to commute, basically, leaving their families at home on the weekends, coming in for a 2.5-day week, basically. There was no longer not only any interchange between the two parties, there wasn't any interchange or exchange between intra-party. And so the Congress no longer can operate without some sort of element of trust between the members who are dealing with each other, looking each other in the eye. And back when I first came to Washington, you couldn't avoid running into a senator or a congressman of your own party or the other party at some parent-teacher conference at school, and because the families were all brought here, and they would get plenty of time to go home or home leave to politic. But with the cut in the rates, and then Gingrich paying, allowing members to draw on their pay, basically, that they don't have to, it doesn't cost them anything. So that to me is where the breakdown has started. There just isn't any. And if you scratch, this I get from my daughter, who's sort of generation of my two panelists, top flight reporter, now raising two kids, so not reporting on a daily basis. But she finds the whole system to be totally crazy. I mean, she doesn't understand how any of it could ever have worked, and she doesn't understand how this works. But it doesn't involve the Congress anymore. And she says that she's written several articles about the Congress, and she says you scratch any congressman, you scratch them pretty hard and press pretty hard, and you'll find out that most congressmen hate their job. Why do they hate their job? Because they don't have anything to do.
It's unbelievable. All right. Well, moving in a little bit of a different direction, many social conservatives have been disappointed by the rulings of conservative justices or judges who tend to lean to the right on economic issues, but go along with their liberal colleagues on social issues. So this has led to some debate among conservatives between those who embrace an originalist jurisprudence in the tradition of Justice Scalia, drawing from the legacy of Madison and Jefferson, and those who wish to go beyond originalism, or at least infuse it with a greater sense of the common good, perhaps like Harvard's Adrian Vermeule, taking Hamilton as their model. What do you make of this development and debate on the right, and do you think it has any legs? Perhaps Josh is the best person to weigh in on that one.
Yeah, no, thanks, Johnny. So look, I think social conservative frustrations at the core, which is not exactly a new phenomenon. Obviously, this has been something, I mean, I'm not going to kind of redo or retell the entire history of the failures of Republican judicial nominations, going at least as far back as, Dwight D. Eisenhower tapping Brennan in the election year battle of 56. But suffice to say that not all of Republican nominees have had the mettle and the fortitude to stick to their convictions, or at least their purported convictions, in particularly social conservative kind of culture war-esque cases. And this past term was a particularly difficult term from that perspective, with obviously the Bostock decision, the Title VII decision, a 6-3 decision where one of our own, the Republican Party Federalist Society vetted Neil Gorsuch wrote the lead opinion. It was, from my perspective, an intellectually indefensible opinion, reading the word sex in the 1964 Civil Rights Act to include sexual orientation and gender identity, a concept that didn't even exist at the time of 1964. And of course, the day after Bostock came down, Senator Josh Hawley took to the floor of the U.S. Senate to essentially say that this is a crisis point. This is a crisis point for the legal conservative movement. If our own purported interpretive methodologies, originalism and textualism, have gotten us here, then are we doing this correctly? I mean, if our interpretive methodologies are at such easy risk of getting manipulated and distorted by purportedly good faith actors, perhaps there's something wrong with the methodology in the first place. So, Johnny, you mentioned Adrian Vermeule, who's a friend, in full disclosure. Last March, I spoke at Harvard Federal Society just before the virus struck. So I guess it was early March. And I got coffee with Adrian afterwards, and he was telling me about this essay that he was planning to write. I was very excited. And, his essay heard around the world was what he called common good constitutionalism, which was calling for a full ditching of originalism in favor of an overtly moralistic natural law jurisprudence. I was not personally fully persuaded by that. And the essay that I wrote in response, and it's kind of a working project for me that I'm talking to numerous Federal Society chapters on, is what I'm calling common good originalism, which is purposely intended to be somewhat of a middle ground between the legal positivism of the status quo, which I partially blame for getting us decisions like Bostock, and the overtly natural law jurisprudence of someone like Adrian. And you're right to flag Alexander Hamilton. My basic contention from a kind of a jurisprudential theoretical perspective is that originalist discourse, pedagogy, the way we've vetted nominees, the way we've discussed originalism in law school curricula, in the legal profession itself, unduly emphasizes procedure and positivism, liberal Enlightenment procedure, to the oftentimes complete exclusion of the overarching substance that our entire legal and constitutional edifice is oriented towards in the first place. And the framers of the Constitution, they told us substantively exactly what they were trying to do. It's right there in the preamble. It was written by Governor Morris on the drafting committee. He was a Federalist Party, not Federalist Society, Federalist Party icon, part of the party of Alexander Hamilton, John Adams at the time. And in the original two-party system, it was the Federalist Party that was kind of the more nationalist, kind of health of the nation, kind of common good, health of the communities, communitarian-oriented party. And from a jurisprudential perspective, we see this fleshed out in such debates as the Necessary and Proper Clause debate, where, as you said, John, it was a Jeffersonian, Madisonian wing that preached that the Necessary and Proper Clause should be a quote-unquote absolute necessity test, basically a real stricture, a true straitjacket upon Congress. The Hamiltonian wing said that it should be interpreted a little more flexibly. Hamilton elaborates on this in Federalist number 33. And it was actually the Hamiltonian vision of that clause that was vindicated by Chief Justice John Marshall in the McCullough versus Maryland case of 1819. And I'm still fleshing it out. This is a work in progress. I'm hoping to have a law review article sometime this next year, probably. But my basic contention is that slightly more flexible common good approach is our actual Anglo-American inheritance, going back to the common law. And that a lot of originalist discourse has gotten overly bogged down by an emphasis on procedure and positivism. And we've forgotten the substantive ends to which we are fighting for. So I think that we are at a crisis point in the legal conservative movement. This was a very rough term, to put it mildly, this past term. Bostock obviously not being the only example. There's plenty of other fodder there. But I am hopeful that Amy Coney Barrett, even if she does not necessarily share some of what I've just been saying, I'm hopeful that she, at minimum, will help us to achieve some of the results that I think all of us on this panel hope to see.
If I could jump in, Johnny, and second the notion that that the common good and morality is at the heart of the Judeo-Christian ethic and the inheritance that we took in as we formed our country and wrote the Constitution. If you look at the Scottish Enlightenment, which I think had a much bigger impact on that plus John Locke, who was a century earlier, much bigger impact on our Constitution and has really been acknowledged. For Adam Smith and for Samuel Johnson, who was at first sort of a rival and later in life they became close friend. For that generation, Johnson was, of course, a Scot, but Boswell was. If you look at that generation and you look at what they gave us, it was based on Wealth of Nations, the basis for it, and the more important book Smith always thought was the predecessor book he wrote called The Theory of Moral Sentiments, and the whole thing is based on what he thought was the higher moral good. If you were to have him say, all right, compare socialism versus free markets from a moral point of view, he would say, well, of course, free markets are far more conducive to a high moral behavior because it's the golden rule: do unto others as you would have them do unto you, or as we're commonly brought up on, what goes around comes around. And I think that's the basis for the rule of law, the whole Judeo-Christian ethic, everything that we've inherited. So I would agree but I do think that some of the policies do matter, that free markets, if you don't have free markets, you end up with corruption and you end up with amoral behavior, not moral behavior.
That's a good point. Rachel, do you have anything to add? Do you feel like the conservative legal movement is in crisis, or are things firing on all cylinders?
Well, I think the interesting thing about this discussion is that everything we're talking about now is linked to what Ambassador Gray was talking about before, which is the fact that Congress does nothing, right? The fact that our courts matter so much and the people we put on them matter so much is because Congress matters so little. And so all of our major questions are being outsourced, which is why this discussion, this sort of intra-party discussion over how we sort of vet and come to judicial nominees is so important, because if we don't get it right, it has a lot of practical implications for how we are going to treat our judges going forward. The left already does this, right? The left, you never have to guess where Kagan or Sotomayor is going to be on any question, because the left makes them take blood oaths to certain outcomes, right? On the bench. On the right, we don't do that because of a philosophical commitment to sort of a neutral, constitutionally based judiciary. But the more we make judges our politicians, the more they are going to be treated that way. And so I think you're seeing a frustration among social conservatives who've said, well, why aren't we getting the outcomes we want? Because we were told by our legislature, we won't do anything, but we'll confirm judges who will. And so what happens when they don't get those outcomes? So I do think we are at a very important point for not just sort of our current conservative legal movement, but for our conservative politics going forward with how we treat our judges. And so we have to get this right, I think, or how we treat democratic self-government in this country is going to change, because it's effectively going to be a 2-branch system, not a 3-branch system.
I have a question from the audience about natural law. Someone writes, have you any ideas why natural law is almost never brought up in confirmation hearings? Is it so out of vogue or perhaps radioactive that no substantive questioning of nominees to the Supreme Court takes place?
I mean, I can speculate on this. Look, as a fairly recent law school graduate of University of Chicago, one of the nation's top law schools, natural law does not factor into the contemporary law school curriculum. I think a plurality, perhaps even an outright majority of law school graduates of our most venerable legal institutions graduate law school every year having the flimsiest, most rudimentary conception, if any conception whatsoever, of what natural law is. So to tie it back to one of my previous comments on this most esteemed panel, as a basic matter of civic efficacy, I kind of question how many people out there, outside of the very erudite, informed viewers who are watching us right now, understand what natural law is. And I think most people of faith, Jews, Christians, etc., have at worst a vague notion, perhaps a fuller notion of what natural law and the common good would entail. But certainly, looking at the legal curriculum, there's a lot of there is ample reason to be deeply skeptical as to how many of our top trained lawyers, certainly absent any kind of external religious upbringing or religious involvement, would have any sincere thoughts on it, just to say nothing of the U.S. senators on serving on the Senate Judiciary Committee. The other quick point is, I'm reminded of Michael Pack's excellent documentary on Clarence Thomas. I can't remember the name of the documentary, but I saw it in theater way back in February, January. It's apparently out now. Would encourage everyone to watch it. It's really wonderful. From my perspective, Clarence Thomas is the single greatest living American. I'm not even sure it's close. But I'm thinking back to one of the flashbacks in that documentary when the then Judge Thomas is at his confirmation hearing, and we've all kind of seen the clip of Joe Biden questioning him about natural law. And then Judge Thomas did fine. He handled himself as he always does, with composure, poise, and he did quite well in that line of questioning. But I think Republican judicial nominees probably after that, and after seeing the line of questioning that he had to endure, are probably a little more reticent, a little more reluctant to write, opine on it, just because if they have judicial ambitions of their own, they might be dissuaded from kind of putting themselves out there in such a way.
All right. Thanks, Josh. Moving in a little bit of a different direction, I know several of our panelists have written articles on the effects of Amy Barrett's nomination and the SCOTUS interpretation of government regulatory powers. How do you think this would affect things like the environment and energy?
Well, since I've taught energy for some years, I'll take a first crack at it. I'm told by Elliot that I probably would find myself in disagreement with Josh on this, but this is a key issue. I mean, maybe for me, it's my obsession, the administrative state. And we're not talking here about the executive branch as envisioned by the founders. We're talking about an extra branch that they never thought about. And that's these regulatory agencies, some of which are purportedly independent. But even those that are not purportedly independent act with a certain arrogance, which is stunning to me today compared to what it was like when I first came here 40 years ago. And as a result of the congressional abdication we've discussed briefly, I think that she doesn't have much in her record, so far as I know, about Chevron and non-delegation doctrine and some of the issues that undergird much of the scholarship that is being focused. And this is something that Josh, I guess, takes issue with, or some of his colleagues, Vermeil, takes issue with. Stop beating up on the administrative state. Well, I'm not personally, parenthetically, going to beat up on the administrative state since I have had so much responsibility in creating it, I suppose. But I do believe that there are ways to regulate, and there are ways not to. And there are some pretty well developed rules about practices, best practices about what's going on, and the administrative state has just gone crazy. And again, go back and repeat myself. And repeat others. It's the congressional abdication. They've just let it go, and the courts have let it go. And I think this current court is going to correct it. Now, she hasn't written much about this. It's not the kind of issue that comes up in the Seventh Circuit either. She hasn't written anything about this, I don't think. But she's written nothing that would lead one to believe that she would condone wholesale giveaways of authority, abdication by the Congress. I just don't believe, when push comes to shove, that she would approve that. So I think her addition to the 5 justices who are now on the court, who I think are ready to take this issue on and try to breathe some more sense back into the way regulations are approached. I think she would be with that group. I don't think she'd be a leader, but I don't think she would really take on Thomas, who probably is the leader, Thomas and Gorsuch. are the leaders, and I think they have at least 5 votes. It's much easier if you have a 6th to do it. And I think having 6, you might actually even entice Breyer to behave the way he did before he got on the court when he was a Harvard law professor and a professor of antitrust law, which is basically should be a course on free markets. So I think her addition will help, but I don't think it's going to be determinative because I don't think she has much of a track record in the past.
Rachel or Josh, do you have any thoughts on that?
Yeah, sorry, just a quick comment, Johnny, if I can.
Sure.
I worry that our dear mutual friend Elliot has perhaps oversold any possible skepticism on my part. Adrian Vermeule and Philip Hamburger of Columbia Law School, also now of the New Civil Liberties Alliance, the anti-administrative state law firm, have had a very colorful, for lack of a better term, law review kind of series of dueling articles on this issue. I'm on Professor Hamburger's side of that divide. I am definitely an administrative state skeptic for sure. In fact, I remember I was studying for my admin law final during my winter quarter, my final year of law school at the University of Chicago. And, had my priorities not probably in line as they should have been. I was actually watching a Republican presidential debate instead of studying. And I was very excited when an administrative state topic was actually raised during this presidential primary debate. And I remember quite giddily making my Facebook status something along the following lines. I said, make Schechter Poultry great again. Schechter Poultry, of course, being the New Deal era case, standing for the basic proposition that the non-delegation doctrine by which Congress cannot delegate its legislative powers to unaccountable administrative state bureaucrats. That was the last time the court held that was valid, was back in the New Deal era. So I'm definitely not an administrative state apologist whatsoever. My only bone to pick, and I wrote this in one of my numerous kind of post-Bostock articles back in June, is that the White House counsel's office, our friends at Heritage Federal Society, the entire judicial nominations apparatus, I think has become a little overly obsessed with administrative state issues, perhaps to the exclusion of some of our more kind of civilizational bread and butter social cultural issues. That's really my only bone to pick. Look, Kavanaugh and Gorsuch, their backgrounds really were more administrative law heavy than anything else. I mean, when he was then Judge Gorsuch on the 10th Circuit, he was kind of an anti-Chevron doctrine crusader. Judge Kavanaugh on the DC Circuit, that was obviously his wheelhouse by definition. So my only contention, and I think Amy Barrett really personifies this, by the way. She's a 7th Circuit judge from the American heartland, born in Louisiana, went to college in Tennessee, law school in Indiana. I just think that kind of an over focus on kind of the DC Circuit administrative law scene, given the social conservative disappointments, it might be time to try to balance it out with a wider variety of scholarly expertise among our judicial nominee class. But I'm definitely not an administrative state apologist or anything like that.
Yeah, I think, Josh makes a good point, I think, on this, in the sense that I think from a practical perspective, a political perspective, a lot of the frustration has been, Republican judges are very good at admin law cases. That's where a lot of their expertise is rooted, but less so on some of these cultural questions. And as a practical matter, kind of going forward, that's something that I think a lot of conservatives in DC are asking themselves is, have we rested on our laurels too much in that school of thought? Have we not sort of been more skeptical and vetted more aggressively on some of these other questions, looked outside that sort of legal pipeline that we have, that we rely on? Do we need more voices in the room? And so that's, I think, the question for the legal movement going forward is, the preordainment process emphasizes admin law to a great extent. Should it include other areas? And so that, I think, to the point Josh made, Amy Coney Barrett isn't necessarily in that, she has a lot of credentials, but I think having her come from the heartland a little bit outside of the sort of, DC Court of Appeals pipeline, I think is going to be good for the court.
Thanks, Rachel. Another question from our listeners. With regard to the Affordable Care Act, the Democrats feel that they did, in fact, legislate and that it's the Republicans who are now using the Supreme Court to legislate from the bench to overturn the will of the people. So for the ACA, should we not remind the Democrats that the issue is not legislating from the bench, but rather the constitutionality of the ACA?
So I can start with that. I think it's a fair point. I don't think legislating from the bench is exclusive to Democrats by any means. I think you see a lot of Republicans that prefer to take these big questions to the courts. They reject the accountability of legislating. They don't want to be on the record voting for or against these big cultural questions. We saw this post Bostock. I thought it was very concerning, actually, the number of Republican senators who were transparently relieved that the courts had handled what is essentially a question of civil and social order. They were very happy that they no longer had to deal with that. And, I think you're seeing that a little bit with the ACA in the sense that, the Republicans held both the House, the Senate, and the White House for 2 years in the beginning of the Trump administration. Did they go after any of these big questions? No. They didn't attempt to take on Obamacare, really. They didn't do they didn't aggress hard on any sort of social pro-life questions. They just, even DACA, these big immigration questions, they dealt with them a little bit, but not aggressively, and they outsourced it all to the courts. So I don't think this is exclusive to the left. I think the right does this as well. But the flip side of it is this: if the ACA is overturned by the Supreme Court, the legislature can respond. I think you're seeing these senators act like they're completely helpless in these hearings. It's this learned helplessness of, well, the courts are going to just do things to us. Well, no, they're actually in a position to respond. And I would like to see more of that accountability and responsibility acknowledged by the senators themselves. But because until they do, the courts are going to be all that matter.
All right, we've got a question on religious liberty. Religious liberty seems to be on the mind of many conservatives, especially as it concerns the court. What exactly is religious liberty in the framework of constitutional rights, and how has that been understood in our unique American legal and cultural tradition?
I'm happy to weigh in first on that one. Religious liberty viewed from one perspective is actually one of the rare jurisprudential bright spots from a conservative perspective over the past 15, 20 years or so. There have been a lot of very narrow rulings, Masterpiece Cake Shop, the Bladensburg Cross case from last term, but I flagged both of those because even though the holdings in those two cases were narrow, they were both 7-2. We even had Justices Breyer and Kagan, I think in each case, sign on to narrow holdings. This most recent term, it was yet again a lone bright spot in the Montana case. We had, I can't remember the name of the counterparty, but Montana Department of Revenue. We had a huge blow to the anti-Catholic bigotry that is the so-called Blaine amendments dating back to the late 19th century. So religious liberty has overall been a bright spot. And in fact, on November 4th, I guess the day after the election, there's a Supreme Court oral argument in the case Fulton versus City of Philadelphia, which is probably one of the court's better opportunities, if it is so inclined, to cleanly overrule the Employment Division versus Smith precedent from 1990, which, at least from my perspective, is almost assuredly actually the worst majority opinion that the late Justice Scalia, who of course was generally wonderful, wrote. In Smith, the court basically held that a facially neutral law, you don't have a constitutional right to an exemption from a facially neutral law. I'm dumbing it down, oversimplifying a little bit, but it essentially got Congress to statutorily pass the Religious Freedom Restoration Act in 1993. And these religious liberty cases have oftentimes been fought on statutory grounds. The Hobby Lobby case of 2014, 2014 being a good example of that. But it would be really wonderful. And my former boss, Judge Ho, the Fifth Circuit, has written at this at length in his early Fifth Circuit tenure. If the court could once and for all overturn Employment Division versus Smith, and I'm cautiously optimistic that is one doctrine that we actually might have the votes to do with a Barrett confirmation. The votes actually seem like they might be there. I wouldn't count on Roberts, but I would feel reasonably confident that we perhaps have 5 votes.
I would agree with that. And Josh, you probably know we have a case bouncing around in Oregon, which is sort of a knockoff of the Masterpiece Bakery case. And that could be a vehicle where they take on Smith. But I agree with you. It's gonna be addressed and it's going to be changed. That's my and I think it will be easier for the 5 conservatives there now. Be easier, much easier with Judge Barrett on the bench. And I think that, generally speaking, some of these issues are, they tend to come back. There's the old, I've now forgotten the name of it. I've had an amicus brief, but the question about whether school choice Cleveland case way back 10 or 15 years ago, whether that was violated the First Amendment Establishment of Religion clause. And that keeps coming back, whether the Blaine amendments are constitutional because they prohibit, federal aid or state aid to Catholic schools, basically. So you couldn't do a voucher program based on state tax exemptions. I'm oversimplifying, but that's going to make a big difference too, I believe, when that finally gets addressed, because the biggest losers there, are not white Catholic parochial school students, but the biggest losers are blacks in inner cities who desperately need the teaching of or the discipline of what the Catholic schools still are offering. Hanging by a thread, I think, but still offering. And having more money out there for choice for black parents would be a huge boost for getting rid of the inequality we have on the educational front, but would also be a big boost for the church, which is what bothers many liberals.
Got another question from the audience about today's hearings. Any thoughts on Senator Ben Sasse's sadly necessary lesson on civics versus politics at today's hearing, or any comments on the failure or lack of civics education in America today?
I mean, it kind of stands on its own, I think. It's sort of 2020 in a nutshell, right? A little bit of what we're dealing with is, I think the expectations that people have from their politics, I think, has just changed so dramatically that for so many people, politics is their entire worldview. It's their religion. It's their, the expectation of a full life is all, through their politics. And it's just not the case anymore. And I think, it results in this distorted view of what can be done. And I think it places on, judges, on senators, on congressmen, this expectation that they're never going to be able to meet because our government isn't designed to do those outcomes. And so I think, sadly, the Sass lecture was needed. But I think Senator Mike Lee, I think also gave a pretty compelling lecture too on the role of judges in society. And I think it's a bright line, right? We're seeing bright lines being drawn between how the left and the right not only view the mechanisms of government, but I think, what the outcomes government can preserve and present to people. And that to me was what I took away from the Sass lecture was, sadly, it was needed because the left views our government as the salvation of souls, right? And the right, I think, has an opposite view. So.
Good point. I've got a question about Senator Hawley. Although Senator Hawley famously declared he would apply a litmus test for judicial nominees in the issue of abortion, the questioner thinks we perhaps need to have 37 or 42 more litmus tests. As Carrie Severino showed, Hawley's single-issue litmus test would not have actually achieved, in retrospect, what he would like. Having a whole worldview approach, as the Democrats do from their perspective, why doesn't the conservative legal movement do the same for those it would put forth for nominees to the federal and higher court? Is it too difficult to do?
I mean, I don't think it is. I think Rachel and I are probably in accord on this one. My frustration has gone to the point where I want to see more litmus tests, not fewer. I was very supportive of Senator Hawley's test when he first articulated it. There's been a public tussle between Senator Hawley and Carrie Severino as to this. If I recall, I had a bone to pick with Carrie's stance on whether Justice Alito qualified. In fact, I think Alito actually did qualify if you go back to his Reagan DOJ writings, but really neither here nor there. I guess my only addendum, I had a recent essay for National Affairs on the issue of stare decisis, of precedent. If we're going to go down the route of litmus tests, which again I essentially support, depending on what the test is, of course. I would actually prefer a test on stare decisis over an explicit test on a specific case, even one as grievous and destructive and murderous as the case may be, as Roe versus Wade itself. If we can try to get more justices who take the Clarence Thomas view of stare decisis, which, to oversimplify again, is a deep-rooted hostility to stare decisis, or a deep hostility to anything remotely resembling strong precedential norms as being in tension with our constitutional structure, the supremacy clause of Article 6, the oath of office clause of Article 6, et cetera. I think that would be something that I would love to see. In theory, what Rachel was talking about with respect to Senator Sass, and this can actually go together. In a wonderful world, one perhaps which we do not currently inhabit, we could see senators on the Senate Judiciary Committee actually asking nominees about things like this as a two-pronged lesson. One is for Republican senators' own edification to try and figure out where they stand on this issue, but also on the flip side of that, to try and educate the public a bit. So maybe I'm kind of just starry-eyed dreaming, but that does seem like a pretty nice alternative universe. But Rachel kind of said it earlier. Well, the left knows every single time when their nominee gets on the court where they are going to rule on all the issues where their proverbial bread is buttered, all the culture war issues, Obamacare, every single issue we know before they even opine where a Democratic nominee is going to rule. Republicans don't know that. We've obviously been beaten across the head over and over and over again. Again, I'm not going to retell the very sad history of our judicial noms going back decades, but I think the precedent that Senator Hawley is setting, even if it's perhaps a little crass and imperfect, is absolutely the right attempt at Overton window shifting to try to get conservatives to rethink a little bit about how we should approach judicial nominations in the first place.
Yeah, I would agree, from a very practical standpoint, in the sense that, again, we've been let down so many times that something has to change. And if it's asking better questions, more pointed questions, then it's incumbent upon us to do that, because it is appalling that we didn't know that this was coming from that Bostock was coming from Justice Gorsuch. Frankly, I think it's a failure of the Republican legal movement, the conservative legal movement, to sort of suss that out in advance. And it's incumbent upon us now to do the self-reflection necessary to figure out why and how we fix that going forward. I think Josh may take issue with my representation of this, but I think part of it is that we've relied, too heavily on this idea of, well, I know him, right? This goes all the way back to Justice Souter when, on the question of abortion, we were told by John Sununu, who was the chief of staff for H.W. Bush, oh, well, he's a good guy, I know him. And we didn't ask the tough questions. And there was one guy on the fourth panel named Howie Phillips, that he was the very last person to testify at Justice Souter's hearing. And he came in front of the committee and he said, guys, Justice Souter is on the board of a hospital and he voted to let that hospital perform abortions. Maybe we should take a second look. And everyone was like, well, Sununu told me he was good, so that's okay. And so that sort of attaboy approach, I think, has to change. And I'm not saying that's characterized our approach to every nominee, but I think on the right, we rely, I think, a little bit too much on personal references, when in fact, we actually just need to ask the hard questions, because Democrats have been doing it successfully for a long time.
Well, I feel as though I should say something, since I'm partially responsible, people probably think, for Souter. I was no match for Sununu, who had put him on the New Hampshire Supreme Court to begin with, and Senator Rudman, who was the mastermind behind Souter, kept his involvement secret from me. It was a very clever thing because I think he knew that if I knew he was involved, that there's no way Souter could possibly be even considered. So he hid his identity amazingly well. I will remind people that he was next on the list. I mean, if something had gone wrong with the Kennedy nomination, the next on the list in the Reagan Justice Department was Souter. I don't know. I mean, the lesson from the Souter thing is he never had to deal with any really difficult major issues as New Hampshire justice. His opinions were carefully written, and all the signals of disciplined decision making were there, but you never knew when he was what he would do when confronted with a major case, and so of national import. And so I think that the result has been to depend more and more on what and on the written record, and Judge Barrett's record is, I mean, there's enough written there so that we should be pretty confident of what she's going to do. And, I was pretty confident about Thomas, even though he was only on the DC circuit for a year and a half. He had been at the EEOC for I don't know how long and had quite a record. And so I think that's what Republicans have got to do in the future is they've got to really drill down into the record and see what they've actually written. It's very hard in a one-on-one interview to smoke out some of the, we all tried with Souter because he was a blank page on so many major issues, but it just didn't work. And I think when you can't find out, I think you've got to go looking elsewhere.
I've got another question from a listener here. It seems to me, after watching these confirmation hearings since the Bork nomination, that the Republicans have finally learned how to counteract the Democrats. It took a long time. Do your guests agree?
I'm not sure that I agree with that, to be honest with you. I mean, look, the Democrats' behavior since Bork has obviously only gotten further and further out of hand. I mean, I have a decent vocabulary, but words fail when I try to think how to describe what I watched when I was watching Brett Kavanaugh go through what he went through in 2018. I was clerking for Judge Hill at Fifth Circuit at the time, by the way, and it was I cannot possibly convey how painful it was for me to not be able to publicly express how frustrated I was because I was obviously a federal law clerk. But look, Democrats continue to go to a new low. I for a little while, I thought that this Barrett confirmation would be yet another new low. I now disagree. I think it's not possible for them to go any lower than Kavanaugh. It's just literally not possible. I don't even know what that would entail. But have Republicans learned to kind of zone it out? I mean, the current leadership, the talking points from Senator McConnell, Senator Graham, Grassley, kind of all of the elders and leadership, it seems to evince to me at least some understanding of how the Democrats, and let's just call this what it is. The Democrats are singularly and uniquely responsible for the wretched, sordid state of judicial nominations politics in America. There is simply no way, there is no escaping that obvious fact. You can look at the confirmation results of Kagan and Sotomayor, et cetera, compared to Gorsuch, Kavanaugh, and even Sam Alito himself, of course. Miguel Estrada, the list just goes on and on. So I do take a modicum of solace from how McConnell, Graham, et cetera, are expediting and trying to get this confirmation in before the election, which is obviously the correct thing to do. But I don't know. I mean, I've just seen Republican leadership let us down too many times over the years to tell this wonderful panel and this audience that I necessarily have full confidence in anything that they could say or attempt to do. But the fact that they have seemed to have whipped up the votes to get this confirmation in time before the election next month is something that I think we all should be very, very, very happy and indeed proud of.
Yeah, I do think. Sorry.
Go ahead, Rachel.
I do think that the Justice Kavanaugh episode stiffened a lot of spines among Republicans, but I don't know that it's going to have a lasting effect. I think the fact that this nomination is coming so closely on the heels of that is helpful. I think Republicans, have this institutional memory of what happened, and I think it was very galling to all of us to watch the extent and the depths to which Democrats were willing to go to destroy someone's life. And so I think that did stiffen a lot of spines, but I don't think as a sort of a party, Republicans are prepared necessarily, to learn those lessons going forward. You're always going to have a Jeff Flake that reacts the way that he did, to protesters in the elevator, during the Kavanaugh nomination. You're always going to have, I think, those types of people on the right, and we don't have this lockstep of like, we're going to burn the place down. I think that's good. But, going forward, I just think it remains to be seen how Republicans are going to handle these nominees, because I don't think it's for sure. I do think it's helpful, again, that this vacancy happens so soon to what we witnessed with Kavanaugh. I think that's useful in the sense that we learned something in the short term.
Boyden, did you have any more thoughts on that?
No, what I was about to speak to change the subject or go back to an old subject, just because it's just a story that if your audience hasn't heard it, which they probably haven't, and you may not have heard it, and my colleagues on the panel may not have heard it. But Josh did say that Smith, he thought, was one of Scalia's worst decisions. And there is this great story that Thomas loves to tell of an administrative state case that was argued, well, before Scalia's death, obviously, which invoked Auer. Auer is sort of like a first cousin or maybe even a sibling of Chevron. And it's going to get overruled, almost did once in the last year. And after the argument was over, and Auer had been invoked many times in the context of the argument in this case, at the end of the argument, Scalia leans over to Thomas and says, Clarence, I think that Auer decision was the worst decision ever made by the Supreme Court. And Thomas said, Nino, I feel your pain. You wrote it.
Great.
So it's best to have a little, not be so tough on, what the Republicans have done. I mean, it's there's a pull to the left in every field when you get into this town, and it affects its what you might call the greenhouse effect, for Linda Greenhouse, the great New York Times reporter, now retired. There just is a pull to the left, and that's one of the things that I so admire about Thomas, and I think it's a result of the fact that he doesn't watch television and doesn't read the newspapers.
Good point. Moving on to another question from our audience. On the Republican side, we have some principled people who will stand against the political tide. Are there any Democrats who may stand for principles in the civic sense that Ben Sasse discussed?
Hard to say. I mean, if we're naming names, Joe Manchin is obviously the most moderate of the Senate Democratic caucus. I'm not really sure what Senator Manchin's thoughts are on, like the art of civics per se. But, he's the kind of person that you could see put himself out there. I don't actually recall what exactly Joe Manchin said about his Senate Democratic colleagues' treatment of then Judge Kavanaugh in September 2018. And I would love to go back and look. I don't recall if he was publicly critical of their behavior. He certainly should have been, but in any event, he's at least the most moderate, both on substance and probably on disposition as well. I had higher hopes for Senator Coons. He's always struck me as someone who speaks well. He's obviously a smart guy, no matter what you think of his politics. He's informed, and he doesn't get hysterical, for lack of a better term, on the Judiciary Committee dais. His recent talking points on Amy Coney Barrett lead me to believe that he's kind of forsaken that facade, that veil of moderateness. He seems to be inching ever closer toward his more radical colleagues on the Judiciary Committee. And I don't recall verbatim what he said over the weekend on the Sunday talk show circuit about Amy Coney Barrett, but he was very, very, very harsh about the current proceedings. So he's someone who I would have thought maybe only 2 or 3 days ago to answer that question, but I can no longer say with any degree of confidence that he fits that criteria.
Yeah, it's interesting that you mentioned Chris Coons, because so I think the demise of the Democrat moderates is something that I've been observing a little bit. And Chris Coons, I watch it in relation to the filibuster as well. Should we keep the legislative filibuster? And that to me is sort of a threshold question for where sort of the Democrats are in terms of, on the spectrum between moderate and sort of very progressive. And I've always relied a little bit on the institutionalists, the institutional moderates like Chris Coons. And he's even come across on the filibuster as well, from someone who defended it as an institutional prerogative for minority rights to now saying, yeah, well, we should upend the legislative filibuster. And when you've lost people like Chris Coons on that question, I think you've lost him on a lot of other things as well. And to the point Josh made, you've lost him sort of, I think, on this question of Amy Coney Barrett, someone that I think we expected to be a little bit more upholding that sort of civic sense that Sass was talking about. But, the pull of these progressive values, I think, is very intense. And again, it's why I don't think a Joe Biden presidency will be anything moderate at all, because the pull to the left on the Democrat Party is extreme and, very, I think, highly felt by a lot of these senators. I expect it to be felt by Joe Biden as well.
All right, 2 more questions before we wrap up here tonight. The first one is about the election. Traditionally, the appointment of a Supreme Court justice doesn't move the needle in a measurable way with voters in terms of turnout. Do you think it's different this time, and if so, why?
So let me jump into that to say, I do think that the list that Trump published 4 years ago, it wasn't one person, it was how many people, 25, 30, I don't know how many people were on the list, but that show of transparency and intent, I think, made a big difference in his election. Mm-hmm. And I think that this proceeding we're now just beginning would also not be as big a help as that was, but would also help him, but for the fact that we're in the middle of a pandemic and there are so many other things, the social unrest, there are so many other things that are going on that this issue, unfortunately, is not going to get the sort of civics attention that I think it should get with the American public. I just don't know. We won't know until it's over how many people watched, but I'm afraid it's not going to have the same educational value that the sordidness of the Kavanaugh hearings had, and the blessing of Trump's candor before during the campaign 4 years ago.
Yeah, I remember within like an hour or two of Justice Ginsburg passing away, numerous friends were texting me saying, Republicans should take the moral high ground, and they should not just the moral high ground, but they should purposely leave this seat open so as to rally the base, on Tuesday, November 3rd, which sounds good in theory. I'm obviously happy they didn't do that. To call it far too risky would be a dramatic understatement. But we should concede that there is something to be said for that. For decades now, Republicans have voted on the court more reliably than Democrats have. The Supreme Court was, if I recall, the #1 most popular exit polling issue in the entire 2016 election. Among the voters for whom was the #1 exit polling issue, Republicans carried it by about 15 points. I think it was 56 to 41 in the exit polling. And Republicans vote more reliably on the court and judicial nominations more generally for the very simple reason that we've been burned over and over and over again in a way that our Democratic friends have not, and that many of our issues, unlike theirs, have been democratically removed from the playing field and have been constitutionalized under the most farcical grounds imaginable. Abortion obviously being preeminent on that list, but hardly the only issue there as well. All that's to say, I do think that there will be at least some residual voting effect if Judge Barrett is confirmed on October 29th, as it seems that she is. Obviously, the election is extremely close to that. It's less than a week after that. But look, if I can just put my political pundit hat for a second here, I mean, Vice President Pence had an incredible debate performance last week against Senator Harris. I think he did all that he could have done and then some. I question how much of that momentum will be squandered by the fact that the second presidential debate is not happening. So I'm not sure how to kind of balance that with what we're talking about here with the Barrett confirmation. But sure, I think there will at least be some positive effect at the polls if she's actually confirmed on the 29th.
Yeah, I think that's right. Although I think the point that Ambassador Gray made is also important in the sense that there's so much going on. It's the variables in this election are just so extreme. But I do think, obviously, Supreme Court matters a ton to conservatives for any number of reasons. So, I think what happens in the next week or so will matter. Now, had they waited until the lame duck, I think this would have been a different question. Had Senate Republicans not taken the mantle and confirmed Barrett before the election, I think you would have seen an electoral impact, because at that point you have to ask yourselves, why are we electing Senate Republicans if they're not willing to do the job we've given them when they can do it?
One final question. Assuming Amy gets confirmed, where will this administration go down in the history of the appointment of conservative or originalist judges? Boyden, you were involved in this for decades. What's your take on this administration's record in terms of judicial appointments?
It's hard to imagine doing any better, any president doing any better, any Republican president doing any better. I think some credit goes to, not some, a lot of credit goes to Grassley and to McConnell, of course. Those two were very, very important in this. And the Federalist Society, generally speaking, what it's, the education of potential judges and law graduates and whatnot over the last 20, 30 years has been a factor too. But it's really, I have to salute a successor of mine as White House counsel. He deserves a great deal of the credit too. So, but I don't think any Republican president will ever be able to do a whole lot better than this term.
Thanks.
Yeah,
Do any of you all have any other?
Partially.
Oh, go ahead.
Oh, sorry, Johnny. Just quickly. partially Trump has, been fortunate to have had 3 vacancies. Obviously, the incredible gambit that was holding the Scalia Garland seat open paid off handsomely. But then you have the retirement, obviously the passing away of Ginsburg. Three opportunities to nominate Supreme Court justice in one term. Has that ever happened before? I honestly don't know. It might be the first time that's ever happened. But notwithstanding some of my criticisms of Justice Gorsuch, Justice Kavanaugh himself does not, he's had firm convictions in some cases, does not appear to be a Clarence Thomas-esque figure. But notwithstanding that, it's hard to disagree with what the ambassador just said. President Trump, certainly from a Republican presidential administrative standpoint, will have had one of the most successful four-year terms in the history of the Republican Party, for sure.
I'm going to take a little bit more of a cynical view and say this in terms of the courts, is that I think the legacy is to be determined, right? Because this is all the Republican Congress has essentially done, is confirm judges. And that may turn out to be the best thing that's ever happened. It may turn out to be middling, but they have no other legacy. It's just this. So we have to hope that, but in terms of sheer quantity, they've done more than anyone. But I think this is the one leg they've chosen to stand on. So let's hope it's a good one.
And on that note, we'll conclude our conversation tonight. Thanks so much, Boyden, Josh, and Rachel, for being a part of our conversation. And thanks to all the viewers for your generous support of ISI and our mission to educate students in the principles of liberty. This evening conversation will be available online on our website, social media channel, and YouTube channel. So I would encourage you to share it with your friends and family. Thanks, and have a great night.